It is August 7th of 2026, and this is the Court Gallery. We begin with September on this 7th day of August. Someone actually bailed her out, and now she's missing again for the 15th time. Judge Middleton is not happy. Then, a messy parking lot screaming match turns into an all-out Donnybrook, fueled by a terrible breakup and very bad decisions. Finally, we end with a landlord-tenant dispute that turns into an absolute masterclass in legal accountability, complete with an attorney delivering a brutal receipt-filled takedown of a tenant's endless lies. Could a tenant actually find themselves sanctioned by Judge Simpson? We're about to find out, and it all starts right now.
Good morning, Miss Conway. Good morning.
Sorry, good morning, sorry.
These are multiple cases in the matters of People versus Elizabeth Conway. Miss Conway is here in the courtroom. She's in custody. She's with her lawyer, Mr. Luke Knopfsinger. She has multiple charges, most of which are under city ordinance, but there's at least one that's also under state statute. So Mr. Tim George is here, and Abby Stoll is here from the state prosecutor's office. Ms. Conway is charged with assault and battery in file 261324. She's charged with trespass in 261325. She's charged with retail fraud in file 261326. She's charged with larceny less than 200 in file 261412. Ms. Conway has been here quite a bit in the last 2 or 3 years. She has been sent to the Center for Forensic Psychiatry for a competency evaluation in the past, and she was found to be not competent. She spent a long time, maybe 9 months, at the Center for Forensic Psychiatry, and she was restored to competency. And those cases were resolved. She's come back. She's mostly homeless, and she's gotten in these new problems. I would indicate that our jail liaison, Lauren Frank, is here from Pivotal. She is a very valuable resource. She's aware of Ms. Conway and her circumstance and has been working on this matter. Ms. Conway has been in jail today for 25 days. These are misdemeanors, and in theory, she's entitled to a PR bond after 28 days if she's not able to post a bond. Ms. Frank had done a petition through the probate court, which we felt was the appropriate course of action for hospitalization. Well, we had a great plan, except they let her walk in the front door and out the back door. And so we didn't get a placement. So I met briefly with Ms. Frank and Attorney Knopfsinger this morning. I didn't have the prosecutors there, so I didn't want to go too far. But if I understand it, Luke, there's a plan here for Elizabeth. And what is that plan?
Yes, very similar, Judge, to the last time we were here. This time, Ms. Franks is going to essentially escort Ms. Conway to the hospital. She's going to file a mental health petition. There was a little loophole in the last one, and we're confident that we would have this shored up. Liz is aware of the plan. She wants to go. She's going to be cooperative. And so for today's purposes, Judge, I would be asking for a PR bond. So in all of Ms. Conway's cases, so that we can kind of have another go of it, hopefully get Ms. Conway to a mental health hospital today. And Ms. Franks has done the heavy lifting here.
Yes, she has. Ms. Franks, I understand the plan is to get not necessarily hospitalization, but at least some sort of placement for Elizabeth.
Correct.
Elizabeth, do you agree with that?
Yes, sir. Yeah, I also do need to get some of my meds regulated.
Yes. Are you taking your
Yeah.
medications now?
Yeah, I'm taking meds right now.
All right, Mr. George, most of these cases are yours, and I know you've been involved in this discussion, but do you agree with this plan?
Yes, Your Honor.
Abby, you on board with this as well?
Yes, Your Honor.
All right, I'm going to grant a PR bond in each case. Right over there, I guess we got a ways to go. With a condition, cooperate with Pivotal, sign a release,
Yay.
and not leave any placement without permission.
I didn't get 3 questions from that. I'll start it back.
So Elizabeth, this is what you've needed for some time. We need a place for you to be. You can't keep living on the street. It's dangerous for you. You got punched earlier this summer, about knocked out cold. You've been living in the alleyways. We need a better plan. So you're going to be taken back to the jail. They're going to do PR bonds. You're going to go with Lauren to, now one problem, and I hope this doesn't bite us, is you've been trespassed from Three Rivers Hospital. They've said that you can't go there because you've caused disturbances there in the past. You're going to go there under the escort of community mental health, and hopefully they will allow you there for treatment purposes, because we no longer have a hospital in Sturgis.
It was there last year when I went.
Yes, well, I'm disappointed that they took this so cavalierly, and this happens a lot. We go through a huge effort to get a mental health petition. There's some visiting emergency room doctor who has no interest or office in this matter and simply says, oh, they look all right to me, and then let them walk out. And I can't tell you how many times that's happened, but we got Ms. Frank on top of it, and we're going to see if we can get something and eventually get you placed. So you got 2 more in custody. Do we know what we're doing with them? Who's got the other in custody? Who else is in custody? Wired and
I have Mr. Lowry.
what are we doing with Mr. Lowry?
His felony status in a couple of weeks, Your Honor, switch to extra trial.
All right, you can take Mr. Lowry and Elizabeth back. We'll see where we are. Elizabeth, I hope things get better.
Yeah, me
You seem
too.
good today. You must be on your medications. Some of these last times I've talked to you, we couldn't even communicate, but I want you to be somewhere safe. And now you've still got a bunch of criminal charges pending. We're going to see what's going to happen with those. I'm going to set an attorney pretrial for October 2nd
Okay.
at 8:30. We'll see what's going on with all of these cases.
Okay.
All
Thanks.
right. Thank you. All right, Luke, stay right where you are for a minute. We're going to call September Knowles. Thank you, Ms. Frank. You're a lifesaver. All right, there's another wayward soul. September Knowles has about 10 charges. Disorderly person filed 26670 SM. Disorderly person 26672 SM. Trespass 261217 SM. Disorderly person 26386 OM. Disorderly person 26427 OM. Disorderly person 26982 OM. Disorderly person 26983 OM. Disorderly person 261131 OM. Disorderly person 261112 OM. And City of Sturgis littering 261511. Mr. Nossinger also drew this assignment. Every single one of these is a discrete, separate incident. They're all over the county. They're in Leonidas, they're in Sturgis, they're in Three Rivers, they're in Constantine. She's at Applebee's, she's at the fire station, she's at the hospital. And every single time she failed to appear, every one of these, she failed to appear on her ticket. So she finally got arrested. And I spent a long arraignment, arraigning her. I think Luke might have even been with us. I don't remember. And Judge Pattison set bond at $1,000 in one of the cases. And I set bond at $250 in all the others. There were 8 $250 bonds. So she posted. I did not expect that she was going to post bond. Somebody posted her bond. And Quick Bail Bonds what posted her bond. If I were king of the world, I would forfeit Quick Bail Bonds $3,000 right now, immediately. Anyway, of course, to nobody's surprise, she's failed to appear again. And Luke, did she ever even contact you after the arraignment?
No, Judge.
All right, this is literally like the 15th time she's failed to appear. I'm going to do a bench warrant in each case. I don't know. I called the jail to find out who actually posted her bond, and all I could tell was Quick Bail Bonds. I'm not sure who put up the money with Quick Bail Bonds. Anyway, I'm going to do a bench warrant in each case of $2,500 cash or surety. We need to hold on to her long enough to deal with this. No 48-hour hold. To an immediate notice of bond forfeiture. Quick bail bonds. Maybe they can find her. Much like Miss Conway, I've watched Miss Knowles' deterioration over the years. And we need to get a plan of action. And I talked with her about that. And Miss Frank was going to work with her at the jail, but to all of our surprise, she bonded out and promptly never called her lawyer and then never showed up for court. So Luke, you draw 2 tough assignments. One of them we're making some progress, and the other we got to find the person before we can deal with it. So Abby, I think all of these are ordinance, if I'm not mistaken.
Your Honor, I have one disorderly person.
All right, well then, 8 ordinance and 1 misdemeanor, $2,500 cash or surety. She's like a will-o'-the-wisp. You have her and then you don't. And this time I want to hold on to her till we can do something. All right, Luke, thank you.
Thank you, Your Honor.
All right, are you Aaliyah Sutherland?
Yeah,
Could you say your name for me?
Aaliyah.
All right, I got it right. You're charged with domestic assault. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500, but also prohibit you from using or possessing a firearm for 8 years at least. This is an interesting plea. The prosecutors agreed to dismiss this charge for a plea to disorderly person. This happened in the city of Three Rivers. Three Rivers has an ordinance that can make disorderly person a civil infraction. The fine for that civil infraction is $100. Civil infraction is not a crime. It's like the last case we just did, which was no proof of insurance. Ms. Stoll, you agree with that terms?
That's correct, Your Honor.
And Mr. George, on behalf of the city of Three Rivers, you agree as well?
Yes, sir.
All right, well, that's an interesting plea offer. All right. Other than this, Ms. Sutherland, did anybody promise you anything
No.
or threaten you?
Mm-mm.
All right, who is Deandra House to you? Who is Deandra House to you?
My ex-girlfriend.
All right, and did you and she get in some sort of quarrel or argument or disagreement on July 18th?
Yeah, it was just a bad day.
Sounds like it. I was on vacation that day, as I recall. It was a pretty good day, but we'll see what happened to your day. Well, I don't have any affidavit or booking sheet or anything. Tell me what happened.
I gotta for real go into detail.
What's that?
I for real gotta go into detail.
Well, where did this happen?
In Three Rivers,
At where?
in apartments.
All right, did this happen? Did this go outside the apartment?
Yeah, it was outside.
All right, and so were you and she yelling at each other and having a disturbance outside in the parking lot?
No, I tweaked.
Say that again?
I tweaked.
Tweets.
Tweaked.
You tweaked.
Yeah.
All right, so from methamphetamine?
No,
I crashed out, like tweaked, like.
All right, well,
Mad.
tweak may mean different things to different people. But, all right, so anyway, you lost it and got into it with her in the parking lot.
Yeah.
All right, that's sufficient. Are you satisfied with that, Ms. Stoll?
Yes, Your Honor.
All right. And you say X. So who's at the, you're now in Centerville, right here in Centerville?
No, I don't stay here.
All right. What's your, don't tell me you're on the record, but where are you living now? Just what town?
Elkhart.
All right, we're gonna need to get your address before you go, but the fine and cost. Tim, do you happen to have the site for that disorderly?
I can get it.
I do, Judge. It's 4-2 under the city code. It's chapter 4.
I'll still be here though. I'll still work here.
Disorderly person ordinance. Civil infraction. All right, the fine and cost under the ordinance is $100. And that is due 9/7/26. Can you pay that within 30 days?
I can pay that today.
All right, very good. If you pay it now, I guess we don't worry so much about your address. All right, if you take Miss Sutherland out, she can pay that fine. She's good to go. All right. Deandra House is the other half of the Sutherland case that we heard earlier.
And it's my understanding that the prosecutor will offer a civil infraction if she would prefer that over disturbing the peace, which I believe that's what she would do. So I don't know if you needed an advice of rights form for a civil infraction.
Well, no, she's heard me say it, but we will proceed. The co-defendant, Ayanna Sutherland, pled guilty to the Three Rivers City ordinance of disturbing the peace. She told us that she lost it. Her word was tweaked, that you and she had been in a relationship and you got in a fight and were yelling at each other out in the parking lot of your apartment complex. That's a sufficient factual basis for disturbing the peace ordinance violation. What you're charged with is domestic assault. That's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500, but also prohibit you from using or possessing a firearm. This lesser charge is a civil infraction. It's punishable by a fine only. The fine is $100. Other than that, did anyone threaten you to get you to plead to this?
No, sir.
Or threaten you? Or threaten you?
No, sir.
And once again, Ms. Stoll, you confirm that?
That's correct, Your
Mr.
Honor.
George, you do as well? All right, I told you what Ms. Sutherland told me. Do you have any disagreement with that state of facts? You guys got in an argument, you were yelling at each other on the parking lot of your apartment complex?
I wasn't doing too much yelling, but yeah, that's what happened. She crashed out.
Do you remember what you were fighting about?
A breakup gone bad. I told her we was done, and she sat outside my apartment, that is my apartment complex, all morning. And when I walked out, she slapped me. So it just led to that.
So then now disturbing the peace doesn't matter who was right or wrong or who started it.
Mhm.
Was there a quarrel, argument, a disturbance in a public place? And you accept that?
Outside of my apartment, yes, sir.
All right. That's 4.2. Cost is $100. Can you pay that today?
Yes, sir.
What do you do, Ms. House?
I work for Amazon, but I'm on work leave right now. My
Which
hand is
plant
messed up.
are you out of?
Hmm?
Which plant are you out of?
The new one in Bristol, Indiana.
People that work there, they don't need to go to a gym to work out. Every day is a workout. You work as fast as you can. All right, well, I don't know where you guys are headed, whether you're headed separate directions or there's more to come, but I don't like to see this. So you go pay your fine, $100. And this matter is a civil infraction. It will not show as a criminal offense.
Thank you.
All right, you're good to go. Terry Holderman. Good morning, Mr. Holderman.
Sorry about that phone over there, but
You're all right. This is file number 261137. Terry Lee Holderman, charged on a ticket citation with driving suspended. Second, verbal warning for speeding. Now, this was in Mendon. It's easy to speed in Mendon, it really is. You come down M60 and the speed slows down. So they didn't give you a ticket, but you're suspended and have been for some time. And driving suspended second is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. You understand?
Yeah.
I'm not gonna fine you $1,000 or give you a year in jail, but those are the maximums. Do you understand?
yes,
You understand?
yes, sir.
All right. And you've also,
This is just gonna be set for final pre-trial.
oh, we didn't resolve it?
No, sir.
Oxy. Well, Mr. Holderman's got a very bad driving record. He knows he shouldn't have been driving, Mendon or otherwise. All right, we'll set a last pretrial. Mr.
Thank you.
Holderman, I don't see that you owe any money to the court. I think you paid all your obligations. But you know you can't drive. You and I've had this discussion. We'll set up for a final pretrial on a Tuesday afternoon. How'd you get here? Today?
Drove.
Well, you can't drive. Yeah. Now, here's the deal. You're not suspended, you're revoked. If you drive home, I'm gonna have the Three Rivers Police or the sheriff pull you over between now and Three Rivers, arrest you, impound your car, and take you to jail. So you gotta call somebody to come get you. You gotta stop driving. You told me you were gonna move to Montville and maybe try to stay out of the limelight, but your license has been suspended for a long time. You know you can't drive. You wish you could drive. I wish you could drive. But you're revoked. and I can't fix it. So call somebody to come get you, or I'll give you a bus pass to get home and have somebody come back and pick you up. But if you drive home, it won't be good. So you're good to go. Sorry it took so long to get to this point. We'll set a pretrial on a Wednesday at 2:00.
Thank you, Your Honor.
All right, Luke's got Dylan Penn, who isn't here.
He is
Who's
not.
charged with disorderly person, Village of White Pigeon. His co-defendant is here. He's not here, and I don't accept his phone call that he couldn't get here this morning. She's here, he's not. The fact that he isn't here isn't accepted. So the defendant failed to appear. I'm gonna give him 48 hours, $250 cash or surety. Did he contact you at all?
He did, Judge. Yeah, he said that he wouldn't be able to get here. This isn't a disorderly person case, and it is gonna be set for last pretrial.
Oh, so we're gonna set a last pretrial anyway?
Yeah,
I'm
so,
still not happy. He doesn't get to phone it in. He's got 48 hours to get in here. Well, then he's got to show his face in here. He don't get to call up and say, hey, I can't get there. He's got a history of not showing up when he's supposed to and not taking things seriously. What are we gonna do with your case? Is that gonna be last pretrial too?
Same, Your Honor.
All right.
Yes, sir.
Then they're gonna get off schedule. All right, I'm gonna set a last pretrial. I'm not very happy with him, but I don't want you on one date and him on another date, so we'll
thank you.
set a last pretrial. I was gonna set the bond at $1 million. You probably post it. All right, so that takes care of Mr. Penn.
Judge. Is Amber okay to go since we kind of addressed?
Yeah, let's take care of her. Have I got her file up here? Amber Carpenter will be set for a final pretrial. I'll note that she was present. She did call, said she'd be a little late.
Contact with our office as well.
She and Mr. Penn are friends, and I thought if she showed up, he should show up. I would have done a bench warrant, but they both want a last pretrial, and if I do that, the cases will get separated. So, Ms. Carpenter,
Oh,
you got $550 with unpaid fines and costs.
yeah, I'm on a payment plan.
I think you are, so keep making those payments.
Thank you, Your
All
Honor.
right, you're good to go.
So does Dylan have a warrant for it or no?
No,
Oh, okay.
tell him I wasn't very happy with him, but
I'm gonna
he's
tell
got
him that he does and that you set it at $1 million.
1 million. All right, Mr. Gibson, let me take these out and give your cases. All right, Elisa Oswald. Ms. Oswald, every week, somebody has to be last.
Yeah.
And today that happens to be you and me. And Abby and Tim.
Literally just walked out.
All right, Mr. Oswald, it's alleged that on June 23rd in White Pigeon Township, you assaulted Jeannie Lynn Bontrager, Christopher David Bontrager, and Chelsea Rice. Those are all assault and battery charges. Assault and battery is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. The notes say you're going to plead to one charge and 2 other counts will be dismissed. Is that correct, Ms. Stoll?
No, Your Honor. That's the offer.
Oh, offered.
but
She
it's been
declines.
Rejected.
All right, I guess I saw plead guilty. So she just
Continue
declines.
further
All right.
proceedings, Your Honor.
I guess I had these upside down. I would have done these earlier. I thought this was a plea. Take a look at this. Ms. Oswald, I don't see that you owe me any money. When I say me, I mean the court. All right, this looks like a humdinger here, but you don't all live in the same house, so there's no issue there. You still live on Lafayette Street in Sturgis? All right, you're good to go. Thank you.
Thank you, Your Honor.
Thank you.
The affidavit says the lady yelled at her to slow down, so she got out of the car and punched her in the lip. And then the Donnybrook was on, so be careful who you're yelling at. Word of advice. Mr. George, thank you for your patience. We did a lot of cases. Abby, thank you. You did a lot of cases as prosecutor, and we did a lot as defender. I don't believe I've ever taken as many drinking driving pleas in one day. I think of the 16 cases we just did, about 10 of them were drunk driving cases. I don't know what that says about our circumstance, but I appreciate all your help this morning.
Court does call the case, People versus Caleb Shaw.
Morning, Your Honor, Raymond Cook for the people.
David I. Coulsd, appearing on behalf of the defendant. Your Honor, I spoke to Mr. Kasham this morning. Apparently, he and his parents were the victims of an attack by some savage lettuce. His parents are in the hospital, and he also has the virus, although he is not in the hospital. And he said, given a day or two, he can get proof of that. But I just found this out about maybe 15 minutes ago. So and he has appeared every time up until now.
Yes.
So I'm going to ask if the court would consider an adjournment. I think the matter is going to be resolved. I don't think it's going to go to trial.
Having had firsthand experience with some particularly savage lettuce, I will leave it to the courts to speak.
Wow, really? I threw all mine away and have
I just stopped going to Taco.
a salad.
I just stopped going to Taco Bell. That's
Well, got lettuce. I'm not doing it. I've always thought lettuce was useless anyway, because it takes more energy to chew it.
Listen, I was having a problem with Taco Bell long before this thing with the
All right. I will adjourn, given those circumstances, jury final settlement conference to October 16th, 2026 at 9. Jury selection, if necessary, following that, October 19th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor. Thanks, Ray.
Tell your client, I hope he feels better.
Thank you,
Does Miss Saxon have something else, or can she leave my court? But no, look, I'm talking to my staff. Court calls the case People versus Devon Gibson, 2 cases.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Edward Dukes on behalf of the defendant. Standing in for the attorney record.
Yes. You're standing in for Mr. Sachs?
Yes, Your Honor.
Your name, sir?
Edward Gibson.
I would move to dismiss.
And Claire, you have no objection to Mr. Dukes stepping in?
No, sir.
Okay. People being unable to proceed in either matter, these cases are dismissed without prejudice.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome, sir. Court does call the case of the People versus Demond Bransford.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Trovia Star on behalf of Mr. Bransford. Mr. Bransford, state your name.
Demond Bransford.
I have before me a plea form that indicates that the defendant pleading as charged to the count of assault and battery, the 93-day offense. There is a sentence agreement to time served.
Correct, Your Honor. Some additional context. This was an assault that occurred at the jail. And did a month or two in custody on this and some other matters. He's sentenced, I believe, on the 15th, on the 18th
Correct.
of August for an attempt resisting and obstructing, the 1-year misdemeanor out there. My understanding he's also on probation on circuit court already. I didn't want to be on 3 different courts of probation, which is why people were willing to do time served by the costs.
And that is correct, Your Honor. The victim was the previous case that you just called.
Got it. Okay, I don't, given the circumstances, I don't think there's gonna be, I'm certainly not gonna have an objection, but he'll still have to go through the probation department to see what happens because it's a victim's rights case.
Yes, Your Honor. I did explain that to my client.
Okay. May I have him sworn?
Do you solemnly swear and affirm the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record.
Lamar Bransford. Thank you. Sir, it is this court's understanding that you're going to plead guilty to the charge of assault and or assault ban. Is that correct? Yes. That's a misdemeanor, punishable by up to 93 days of jail, $500 fine plus court costs. You understand that? Yes. Still wish to plead guilty? Yes. To that charge, how do you plead? Guilty. You understand that by pleading guilty, you'll not have a trial of any kind? Yes. Signed an advice of rights form, is that correct? Yes. Any question regarding any of those rights? No. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Okay.
So yes.
Yes. You understand you're giving up your right to appeal of right? Yes. Are you on probation or parole? Yes. Were you on probation at the time of this offense? Yes. All right. Just so that we're clear, is that one of the probations?
That would be
The circuit.
Circuit court probation. All right. I do have to advise you, sir, that your entry of a plea in this case could then be considered a violation of that probation. You understand that? Yes. As such, if it is considered a violation, that court could sentence you to the maximum allowable under those other charges. You understand that? Yes. Understanding that, you still wish to plead to this charge? Yes. Has anybody promised you anything? Plead. No. Other than what's been stated? Anybody threaten you or coerce you? No. You're doing this voluntarily? Yes. Of your own free will? Yes. And because you believe that you are indeed guilty of this offense? Yes. On the date of March 24th, 2026, 2201 Hogback, the Washington County Jail. What'd you do involving a Devon Gibson that makes you think that you're guilty? I assaulted him.
How did you assault?
Oh, I punched him. Punched him? Yeah. All right. You didn't have his permission to do that, did you? No. And it wasn't an accident on your part? No. Intentionally, correct? Yes. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that? Yes. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
Not from defense, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendants referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be September 9th, 2026, 9 a.m. Bond in this case will continue. All right, thank you. Sir, stop down at the probation department on your way out there on the left, just so we can get the process started. Okay? Okay, thank you.
I watch on YouTube. All of you. That'll work.
Ma'am, thank you so much for telling me that. I do appreciate that and all your kind words. All right. You do the same and have a blessed weekend.
Judge, can I get your autograph?
Harbor Woods versus Shakori Davis.
Good afternoon, Your Honor. Rachel Dornbush, Palace Law, P78301 on behalf of the plaintiff.
Good afternoon.
Alex Henry on behalf of Shakori Davis, the defendant, who I believe is also present via Zoom.
Ms. Davis.
Shakori Davis.
Thank you. All right.
Nakia Smith also might be joining. She's from Friends Indeed. Oh, okay.
You know,
I We just messaged about 15 minutes ago, so I don't know if she's been able to log on or not.
From Friends Indeed.
Yes, this was on my motion for the set aside of the judgment. Basically, before I entered in the case, there was, I think, some agreement made that the tenant would pay some amount of money, there would be escrow release from the court, and that she would get assistance from Friends. It sounds like there was a delay in getting the money from her and
From who?
The money from escrow was released on June 30th. It didn't get received on the ledger until July 15th, which was after the default notice was sent on July 14th. My client was supposed to pay on July 3rd and 7th. She states she did, but the money does not appear in the ledger, and she doesn't have, proof to be able to show that she made that payment. But then she did make the payment in July 20th that would cover the July 3rd and 7th payments. At that point, all that was left was the Friends Indeed payment that needed to be made. But there was some delay in getting that to the plaintiff, and at this point, I think the plaintiff doesn't want to pursue this any longer. They don't want to receive the money, and they informed Friends Indeed of that, I believe, on July 27th.
Okay, Mr. Dornbush.
Your Honor, some of that is true, some of that is not true. And just so the court is aware, I did speak with the court officer at Cope who had the writ in this case, and he is prepared to sign on to Zoom if the court requires to hear anything from him. He's prepared to advise the court what occurred this past Monday. Your Honor, as the court has probably noted, I filed a very lengthy response to defendant's motion to pay the writ and to set aside the default judgment. This case dates back to April when my client filed this case. The court will recall that there was a first hearing. It happened on May 8th. And at that hearing, Ms. Davis appeared. And Your Honor, I'll be frank, I can't recall if she explicitly stated that she was getting a hardship loan from her job that would cover the balance in full, or if it was implied, or she just stated, hey, I'm getting this hardship loan.
I can tell you my note. I have a hardship down here. She indicated she was going to get it.
Yes, and I know there was a hardship. I just couldn't recall if she stated at that date that it was enough to cover the nearly $7,500 balance that was due at that time, or if she just said, I'm going to make a payment before next week. I don't know if the court specified or if there was a discussion, and going back to May, I can't recall. I just remember there was a hardship loan. She expected to have it next week, and she intended to pay it before the next court date, which was adjourned to May 15th. And so with that being said, on May 15th, I believe this matter was set for 3 p.m. and Ms. Davis emailed shortly after 2, I believe it was right around 2:08 p.m., indicating that she had been in an accident, was allegedly taken by ambulance to St. Joe's, and she was asking that the court, that we not seek a judgment and that we adjourn. She sent a similar email to my client around the same time, and I had responded to Ms. Davis indicating that I didn't have authority to adjourn, that I would notify the court of what she had told me, and that Your Honor would decide what would happen based on that. I don't know if she then also got in contact with Your Honor regarding that, and if she provided any documentation to the court supporting her claim of what occurred that day. I did not receive anything. I can't say with any certainty that Ms. Davis did or did not have the incident that she referenced in her email actually occur. She, though, did also indicate that she did receive the hardship loan, that it had deposited in her account. I believe the email that I attached, in fact, I've got it right here. It was deposited in my account this morning. I did not have time to grab a cashier's check. Then I got hit on Washtenaw. I tried reaching out to the rental office in court. The money is in my possession. That's why I wanted to adjourn so I can get the cashier's check the office told me to get. That was at 2:25 p.m. I mean, Your Honor, respectfully, I think the timing of all that's a little bit strange that at 2 o'clock she was already at the hospital. I don't know why she would be heading to the court at some time between 1 and 2 when the hearing wasn't until 3. But
Right.
nonetheless, Your Honor, the court hearing was adjourned. It was scheduled over to the 15th. And on the 15th, Ms. Davis did not appear. A default judgment was entered and the total judgment was for just around $7,500. That balance was to be paid on or before June 1st. Ms. Davis did not pay the balance on or before June 1st. And on June 2nd, the order of eviction was requested. And I believe it was on June 3rd, then that Ms. Davis reached out to my client, Ms. Kenya Terrence, who has signed into Zoom as well, to verify the amount that needed to be paid in order to stop the writ. Ms. Terrence let Ms. Davis know. I believe Ms. Davis had indicated in her email that she had $6,000 and that she could drop off around $1,500 immediately. That email is in fact attached as well as Exhibit A4, Your Honor, to my motion, saying I have 6,000 and I can try to bring you 15-10-23 ASAP. I want to stop the judgment. Ms. Terrence responded that she needed $7,520.23 to stop the judgment amount, even though, as Your Honor may recall, I probably would have argued to the court that at that point she would need to pay June as well, since it was outside the judgment date. Nonetheless, my client was still willing to accept $7,520.23 as of June 3rd. No further response from Ms. Davis, no monies were paid. Instead, I believe it was on June 5th that Ms. Davis then filed her motion to set aside the default judgment, which the court then set for June 12th. In filing her motion, Your Honor, Ms. Davis paid $1,700 into escrow, which was the 1 month's rent. I don't know that any particular grounds were stated in her motion. Nonetheless, on June 12th, Ms. Davis relayed to the court that she had an in-person meeting with Hawk scheduled for Tuesday, June 16th, and that she had the ability to then deposit another $4,500 into escrow, which Your Honor ordered her to do on or before June 15th. Ms. Davis did not deposit the money on June 15th, but I was able to verify with the court that she deposited the $4,500 on June 16th. At the
And
hearing,
just in fairness, depending on what time she came in, it may have been, it may show the 16th, but she may have gotten here on the 15th.
Gotcha. Understood, Your Honor. And so when we were here on June 12th, Your Honor had told Ms. Davis that she needed to relay to her caseworker at Hawk that the deadline for their assistance payment, which at that time Ms. Davis had indicated she expected it to be $3,000, needed to be paid by June 26th. That Friday, Your Honor, after her alleged meeting, in-person meeting with Hawk, I had reached out to Autumn at Hawk to verify, to see if she could direct me to Ms. Davis's caseworker. And I was told that Ms. Davis didn't have an open application with Hawk. I think I received that email from Hawk, Your Honor, on Monday, the 22nd. That correspondence happened on Friday, June 19th, I believe. Ms. Davis did give me a response, and at that point, she made a statement that she that Hawk sent her to Friends Indeed. They haven't called me or anything for my in-person. I have left a message for 2 weeks straight. That was on Monday, June 22nd, Your Honor, which again, the timing of that also seems questionable. If she's been trying to reach Friends Indeed for 2 weeks, then at the hearing on June 12th, she knew she was working with Friends Indeed, not Hawk. And then she knew that she didn't have a meeting with Hawk on the 16th. Because if she was trying to talk to Friends Indeed about her meeting, how could she have an in-person with Hawk on the 16th? So either Ms. Davis wasn't being forthright with the court on June 12th as to her situation, or she wasn't being forthright with me regarding her situation. Nonetheless, I then still communicated with Ms. Davis regarding the situation and was agreeable to working out a resolution, which we did then work out. On June 26th, Ms. Davis and I had lengthy email correspondence seeking to work out a payment agreement that allowed her to A, utilize the $6,200 in escrow, B, wait for the Friends Indeed assistance payment of $3,000, but then also contemplated the July rent, which was going to be coming due in the interim. And that agreement required the $6,200 to be released, which it was. It required Ms. Davis to make I believe it was an $800 payment on July 3rd, and then a payment of around $1150 on July 7th. And then the payment by Friends Indeed was expected to be made by July 17th. And had all of those things fallen in line, there should have been ample time for Friends Indeed to verify her balance and get a check released. Your Honor, Ms. Davis reached out to me, I think, for the first time on July 7th, asking about status of her escrow check. And that is attached as Exhibit A8. She emailed me at 9:40 a.m. asking about it. And I did not have her escrow check. I contacted the civil division. The civil division let me know that indeed the check had been issued on June 30th. We didn't have it yet, and I let Ms. Davis know that I would let her know when I got it. Ms. Davis did follow up with me. And Your Honor, the email from the civil division is attached as Exhibit A9. On July 13th, Ms. Davis and I had additional correspondence where she emailed about the additional fees that we're collecting on her account, late fees, and stating that her belief that we were holding her escrow check. And I reiterated to her, Your Honor, no, we don't have your escrow check. But I did, in fact, reach out to the civil division again to inquire about the process for having it reissued, because it, generally speaking, doesn't take 2 weeks for a check, once it's mailed, to come to our office. And so I inquired, and the civil division had stated at that point that there was a procedure, but they wouldn't typically do a reissuance until a check has been missing for 60 days. That obviously wasn't going to work in this situation. And so I had inquired with my client that we could potentially file a motion with Your Honor to see about expediting the reissuance in light of the situation here. And my client was agreeable to doing that, but they wanted to wait a few extra days to see if it did come in the mail. In the meantime, I verified with my client that they had not gotten the requisite payments from Ms. Davis. And when I emailed Ms. Davis to let her know that, also on July 13th, I let her know our intention would be to pursue a motion, but I inquired to her about her payments for the July 3rd and the July 7th, because Arbor Woods had reported to me they had not received payment, and I asked her about the status of the Friends Indeed payment. And Ms. Davis replied to me on, this is Exhibit A12, Your Honor, Arbor Woods and Friends Indeed told me to wait until the balance reflects the payment. Kenya does not understand why it hasn't hit the account. Friends Indeed needs updated ledger, but we can't send one because my balance hasn't changed. I have my rent and $800, but Kenya said I would still collect fees because of the missing check. So Mr. Henry's statement here to the court, Your Honor, that Ms. Davis dropped off payments on July 3rd and July 7th is not accurate. That is not true. And if Ms. Davis told him that, then she was being dishonest with her attorney, because according to the email she sent me on July 13th, she didn't make the payment because she says she was told by Arbor Woods and Friends Indeed not to make the payment. And my client advised me that they did not tell her that, in fact. And at that point, Your Honor, I then let Ms. Davis know that my client was still willing to accept her portion, the $19.50, but it needed to be paid that day. I had also reached back out to the civil division and asked, hey, can I get the receipts showing that Ms. Davis paid the $6,200, in hopes that she could take that proof to Friends Indeed. Even though I hadn't hit the ledger yet, this court would never allow Ms. Davis to be evicted over a missing escrow check. That would never happen. And I wouldn't have defaulted her over that. I would have contacted the court and said, hey, the escrow check is missing. What can we do to get this paid? And my hope was that in having the receipts from the court showing the money was paid to the court and would then be reissued by the court at some point, that Friends Indeed would be able to rely on that in conjunction with Ms. Davis's promised payments to show that she was where she needed to be for Friends Indeed to release her payment. And I emailed Ms. Davis that information on July 13th at 3:12 p.m. This is Exhibit A14, Your Honor. Ms. Davis attached are the receipts showing the escrow you paid, the court's notes about releasing payment. Arbor Woods cannot give you credit for the payment until they actually have it. The court has stated they will not reissue the check until the check has been missing for 60 days. However, assuming the other amounts are paid and by you and friends indeed, if the escrow check has not been received by 7/17, my client has authorized me to file a motion with the court to expedite reissuance. Said regarding your agreed upon payments, Arbor Woods has advised they did not tell you to wait until the escrow funds were applied. And I do not believe that Friends Indeed would tell you to wait, since by her own statement, they wanted to see her balance at $3,000. I then said, please pay the $800 plus the $1140.61 that was previously agreed and supposed to have been paid today. I said, if it's not paid today, Arbor Woods will file the appropriate document with the court to have the writ issued tomorrow. And then I said, I would suggest you take the receipts and an updated ledger to Friends Indeed after you make your payment to request that they proceed with your assistance. I didn't hear from Ms. Davis, Your Honor, but I did not default Ms. Davis because the escrow money wasn't received. I defaulted Ms. Davis because she didn't pay her portion according to the agreement, and she didn't pay in accordance with the extension that my client granted that they didn't have to grant. They could have proceeded right then and there to get the writ and to evict because she didn't pay her $1950-ish that was due. On July 14th, Your Honor, I did file a notice of default. I emailed it to the court and I emailed it to Ms. Davis. That is, my email to Ms. Davis is attached as exhibit A15. So I let Ms. Davis know the notice of default has been filed with the court. Again, another reminder, you were supposed to make a payment yesterday, you didn't do so. My office received the escrow check, Your Honor, on July 14th.
Yes.
I emailed Ms. Davis at 2 p.m. telling her that I had received the escrow check and that it was being sent to Arbor Woods. We overnighted it to Arbor Woods. Arbor Woods received it on July 15th, gave her credit for it on July 15th. Now, Ms. Davis had made some statements, and I'm not sure, I'd have to re-review Mr. Henry's motion, if they are maintaining their position that it didn't get cashed until the 16th. That might be when the bank ultimately did whatever it did to transact, but it was put on her ledger on the 15th. She got credit. I also then emailed Ms. Davis on July 16th with her ledger showing the applied escrow payment and said that even though the court had signed the writ, because I believe the court had issued it either the 15th or that day, I had let Ms. Davis know that Arbor Woods was still willing to accept her payment and to go through the Friends Indeed assistance process if she then made her payment on July 16th. And my client graciously extended the date for Friends Indeed to pay to that Monday, the 20th. I then said, you must make the payment. This is Exhibit A17. You must make this $1950.67 today. Otherwise, they reserve the right to proceed, and you would need to get the Friends Indeed payment by the 20th. Otherwise, they intend to proceed with the writ. Ms. Davis responded to me, Your Honor, that she was heading to the management office right then and there, that she was heading to the management office that day. Your Honor, court may recall we had a lengthy docket on Friday the 17th, so I frankly did not have an opportunity to even look at this case on Friday the 17th. But on Saturday, July 18th, Ms. Davis emailed me, I suspect because she got served with the order of eviction. And that email traffic, email correspondence, Your Honor, because of how it went back and forth, I just attached the whole thing as Exhibit F. And Ms. Davis emailed me on Saturday, July 18th at 1:13 p.m. Friends Indeed did tell me, wait, I paid, so how was it filed? What do I do? Your Honor, I didn't see this until Sunday, but I did correspond with Ms. Davis multiple times on Sunday. In fact, it was late in the evening, but I did respond, and I reminded her that she signed a court agreement to pay particular amounts on particular days, that she didn't do so. And then my client did still give her extensions that she didn't comply with, and that's why the affidavit or the notice of default was filed. And I reminded her that my client was still extending to allow for the assistance. I tried to verify with her if she did in fact make the payment. Your Honor, I inadvertently referred to it as a payment she was intending to make on Friday because I just lost track of my days. But it was Thursday that she was, July 16th, that she had indicated she was going to make the payment. In this email correspondence, Your Honor, Miss Davis proceeded to tell me that she dropped off $2,000 on Friday, July 17th, presumably because I said Friday, but maybe it was intended to mean Thursday. Either way, that a $2,000 payment had been dropped off either Thursday, July 16th, or Friday, July 17th. And I said, okay, I will verify with my client and I'll get back to you. So on July 20th, I verified with my client that they had money orders totaling $1,951 and that they had just been purchased Sunday, July 19th, the day before. So the statements that Ms. Davis made to me via our email correspondence on July 19th indicating that she had paid $2,000 on either Thursday or Friday the week before were false. They were not accurate. When I questioned her about this on the 20th, Your Honor, she then said something, and I'm not entirely sure exactly what it was that she was trying to say, but in one email correspondence, it sounded like she was saying she talked to somebody at the management office on Sunday, and that's why she went on Sunday to get the $1,951 in money orders. But at some point, she claims she talked to somebody at Arbor Woods, and because they didn't have her $2,000 payment, that was why she went and got the $1,951. I asked my client said no, they did not have a conversation with her about alleged missing money orders from the prior week. And they didn't know what she was talking about. And so I then said, well, great, Ms. Davis, they have the $1,951, but send me the $2,000 receipt you say you purchased and submitted last week, because if you put it in the Dropbox, which you said you did, I would like to try and verify where it's at. Your Honor, I asked Ms. Davis for this thing repeatedly, and multiple exhibits that are attached here. You will see me repeatedly asking Ms. Davis for proof of the $2,000 money order. I've never received proof of a $2,000 money order, Your Honor, and Ms. Davis has never once questioned what happened to her $2,000 money order. She is strangely unconcerned about this $2,000 money order. That leads me to believe, Your Honor, that Ms. Davis did not purchase a $2,000 money order. And was she telling me that to placate me? I don't know. But I have no proof of a $2,000 money order. Ms. Davis's payment was applied, I believe, on Monday the 20th, and she was then sent another ledger on July 20th, showing that she had then paid the amounts to bring her balance under $3,000. I can't speak to what occurred between Ms. Davis and Friends Indeed between that time, other than the very basic statement that Friends Indeed gave me and is attached to the motion, Your Honor. But during the week of July 20th and up until July 23rd, and these emails again are attached as a part of Exhibit A, there was back and forth correspondence between myself and Ms. Davis about when is Friends Indeed going to release the payment. And finally, on July 23rd, I received an email from Ms. Davis indicating, I'm going to find it specifically for Your Honor, but I received an email from Ms. Davis indicating that the check was going to be available for pickup on July 27th, and that either she or Arbor Woods could pick up that check. I let her know, and I'm going to verify for the court. Again, it's one of the exhibits here. This is going to be Exhibit H, Your Honor.
Gotcha.
Ms. Davis, Arbor Woods remains open to accepting the check from Friends Indeed. You will need to pick up the check on Monday, and you must deliver it to Arbor Woods before they close on Monday, i.e. hand it to Crystal or Kenya. Please resend the receipt. So again, still on July 3rd, I'm still asking for this $2,000 money order receipt. On July 27th, Your Honor, I had reached out to Ms. Davis around midday because she had indicated in her email that And this is part of the Exhibit H, Your Honor. It's going to be on page 2, the very first correspondence, where she said, I sent friends indeed. She said the check can be picked up Monday morning by Arbor Woods or myself. She just called. Does that close out my judgment? $3,000 to get me to zero. And I told her I would, that's why I told her I would verify with my client to ensure they were still willing to take the money from Friends Indeed at that point. Because again, now we're at July 23rd and my client had extended it to the 20th and had no answer about that before the 23rd. Because Ms. Davis had told me that the check was going to be available in the morning on July 27th, I emailed Ms. Davis around midday. And this email correspondence, Your Honor, I believe is going to be attached as my apologies, Your Honor.
No, it's
Trying to keep
okay.
track of which exhibit is which exhibit. Something may have gotten lost in translation, but nonetheless, Your Honor, I reached out to Ms. Davis around midday. I remember it being around midday, asking about, did she pick up the check? And there was several correspondence from Ms. Davis about Friends Indeed allegedly being confused by the ledger, amounts not making sense. And so I took it upon myself to reach out to Friends Indeed directly, which admittedly, Your Honor, I should have done from the start. I should have just bypassed Ms. Davis and gotten into direct contact with Friends Indeed to get the information straight from them as to the status of her application. I emailed Friends Indeed. That email is attached as Exhibit I, Your Honor. And this is the entire exchange between myself and Friends Indeed on that date. I emailed Friends Indeed at 1:01 p.m., giving a brief recitation of what had occurred thus far. And I then, because of the various correspondence with Ms. Davis, where she was reaching out to me, she was reaching out to Arbor Woods, trying to get an updated ledger, I then sent a ledger directly to Friends Indeed on July 27th. And asking for confirmation that the check would be released that day. I had a missed phone call around 4:30 p.m., Your Honor, and when I saw the call and saw the voicemail that it was from Friends Indeed, I immediately called back, but it went right to voicemail. I left a voicemail. Then I saw an email from Friends Indeed at 4:31, and this is the on the first page of Exhibit I. Hello, I cannot confirm that assistance will be provided for this client. No check will be issued today. Friends Indeed also will not give clients legal advice. I would like to have a deeper conversation about this matter. I will try giving you a call again in the morning to discuss. Your Honor, I did ultimately connect with Friends Indeed on Tuesday, July 28th. I spoke with, I think her name is Kia, and I believe this is the same individual who signed the affidavit that Mr. Henry attached to his motion. I spoke with her, and she had indicated that Ms. Davis had missed the window for receiving assistance in the month of July due to missed appointments and untimely submissions of necessary documents. She said that they could approve her for assistance as early as August 3rd. And I had let her know at that time that I didn't know what my client's position was going to be, because then another month's rent had come due, but also there was a lot of history with this case. I didn't know. And I told her that I would let her know if my client was agreeable to another extension, and this time into August. And I spoke with my client, and my client said no, they did not wish to do that. And I let Ms. Davis know that. I emailed her. This is Exhibit K, Your Honor, at 1:40 p.m. Ms. Davis, I spoke with Friends Indeed a short while ago. They have advised that you are no longer eligible for assistance this month. Arbor Woods is not agreeable to waiting any longer for payment on your account. It is our understanding that you filed another motion with the court seeking to stay the writ, which was, I think, filed on Monday. which the court has denied. The writ has been issued, and Arbor Woods intends to proceed with execution as soon as it can be coordinated with the court officer. Ms. Davis reached out multiple times, understandably upset about the situation. She emailed me, this is Exhibit L, Your Honor, on July 28th at 3:02 p.m. She stated she never told you I wasn't eligible. She's writing a statement now. To which I immediately, well, I'm sorry, Your Honor, within 18 minutes responded, Ms. Davis, my email to you indicated that I was told you were not eligible this month. Arbor Woods is not agreeable to waiting any longer. I said, I have contacted Friends Indeed directly regarding our communications. I let them know what I told you and what you emailed me. I will await further response from Friends Indeed. If they confirm what they told me earlier today is accurate, then my email with you stands. Meaning if Friends Indeed confirms that they're not going to issue payment in July, then the email stands. I had further conversation, Your Honor, with Friends Indeed that day, and was told that there was a possibility that they could move Ms. Davis back into a July payment because of a situation with another applicant, and they they might be able to do that, and if they could, would my client accept payment? And I spoke with my client, and my client said no. In light of everything that had transpired, they were no longer interested in moving forward based on the defaults that had occurred. And I let my client did though say that they would be agreeable to giving Ms. Davis through the weekend to vacate and to remove her personal possessions herself, which in one of the emails from Ms. Davis is something that she had requested, the ability to move herself out. I did let Friends Indeed know that my client was not going to be agreeable to accepting payment at any point now, and that they did intend to proceed with the writ if she did not vacate over the weekend. That email was sent to Friends Indeed on Tuesday, July 28th at 3:16 p.m. On Tuesday, July 28th at 4:17 p.m., after additional correspondence from Ms. Davis, I responded and let her know that Arbor Woods would not accept payment, but that they would give her through Sunday, August 2nd to remove her belongings and to return keys by Monday at 9 a.m. on 8/3. Said otherwise, they will proceed to execute the writ. I did have some additional communications, Your Honor, with Friends Indeed on Wednesday, July 29th about this matter. And at that point, Your Honor, Friends Indeed let me know that legal aid had been involved. Additionally, Ms. Davis had indicated in an email, I think also on the same date, that she had an attorney, at which point I told Ms. Davis that I could not communicate with her directly. All communication would need to go through her attorney. And in speaking with Friends Indeed, Your Honor, I had said, you can pass my information along to the attorney, or if you want, and they're okay with it, you can pass their information along to me. She had indicated that Mr. Henry was the individual reaching out. And so I emailed Mr. Henry on Wednesday and let him know that I was the attorney handling the matter in the office, and that, I would be his contact. Mr. Henry did reach out to me on Wednesday and again inquired if my client was agreeable to taking the assistance payment. I reiterated to him at that point that no, they were not, but that they were agreeable to a surrender of possession at 9 a.m. on Monday, and that their intentions were to proceed with the order of eviction. Mr. Henry, I think, wanted to get into the details of my client's reasoning on why they were not willing to take payment. And I had expressed to him at that point that there was a lot of history, and that once I received his appearance, that I was happy to get into the details with him, but that I was going to await his appearance before delving into everything regarding what had transpired. On That's during that same phone call, Your Honor, I had inquired to Mr. Henry if he intended to file another motion to stay the eviction, and he indicated that he intended to. He anticipated having his appearance the next day. I don't know that he gave a particular time frame for anticipation of filing the motion, but I let him know that I intended to respond vigorously regarding what had transpired in this case, and that I did intend to seek sanctions in this case, and that what had transpired would be laid out in detail for the court's consideration in reviewing his motion. Your Honor, I received Mr. Henry's motion, I think, appearance and motion, I think on Friday at about 2:45. And so I filed my response. I sent it to the court and to Mr. Henry. It was around 4:30 p.m. on Friday with the attached exhibits. One final exhibit is one, Your Honor, including Exhibit R, which is written confirmation from Friends Indeed. As previously discussed, this client missed the window for assistance this month due to not providing proper documents in a timely manner. They did then go on to explain about the ability to pay it on 8/3, the potential ability to have paid it this month still, and ending. Also, please note, we do not give legal advice. If a client has questions that we cannot answer, we suggest they call their landlord or legal aid. Your Honor, this statement, when I spoke with Friends Indeed, was the response that I received when I had asked about Ms. Davis being told not to make her July 3rd and July 7th payments. I believe that this written statement was intended to be responsive to that issue. Obviously, it doesn't directly state that. And if the same representative is present from Friends Indeed, obviously she can provide her own statement with respect to what that intention was. Your Honor, I provided this very detailed response, and I give this response in detail on the record here before Your Honor for the reason that Ms. Davis was given many opportunities to do her part in this. And at multiple points throughout this process, Ms. Davis provided me with false information. That false information is backed up in the exhibits that I have attached, Your Honor. And additional false information was then stated in the motion that Mr. Henry filed and stated by Mr. Henry today. This allegation that payments were made on July 3rd and July 7th, when Ms. Davis clearly stated to me she didn't make those payments because she claims she was told not to make those payments. Then she was going to make the payment on July 16th, but she didn't, even though she told me she made the payment. But in reality, she made it on July 19th, and it wasn't even for the amount that she told me. Then on July 23rd, the statement that this Friends Indeed check was going to be available for pickup on July 27th, when in reality it was never even available on that date, Your Honor. There was no approval on July 23rd. And so my client was given this information along the way to, I don't induce them into giving, to waiting on pursuing the order of eviction. Your Honor, Ms. Davis defaulted on this agreement multiple times. And so for that reason, my client was not interested in continuing this process with her. This is an action for possession, and given all that transpired, my client wanted possession. My understanding, Your Honor, is that on Monday, the 27th, when Ed Cope, the court officer, arrived to execute various orders of eviction that he had, and I had alerted him to the motion that had been filed, and I alerted him that he should check with the court before proceeding with execution of the order of eviction in light of the motion that had been filed. And he had relayed to me that when he arrived, that Miss Davis was in the process of vacating already. In fact, Miss Davis had called the management office and advised them that her moving truck had arrived and that she would be returning the keys shortly. Mr. Cope, Your Honor, spoke with Miss Davis, saw that she was in the process of vacating on her own. And he may have given her through the day to volunteer to move her own things out. He advised me, Your Honor, that he asked her if she had her key and would she be willing to give it to him. She told him, according to Mr. Cope, yes, I will give you the key, but then realized that it was on the key ring she had left at the truck rental company. And so he then got her permission to have the locks changed. I believe he then directed my client's maintenance team to change the locks, but Miss Davis was not precluded from accessing the home at any time. In fact, when Mr. Cope went to the home at 4:45 p.m., Miss Davis was there. The truck was still in the driveway. He relayed to me that she was waiting for somebody to come to retrieve the truck. He had offered her a final opportunity to do a walkthrough of the home, to which she declined, stating that she had already done so. He relayed to me that at that point she did surrender a key to the premises, which my client tells me is actually not the key, but nonetheless, it's not very relevant at this point because the locks were in fact changed. But Your Honor, they were changed with Miss Davis's permission. And if the court requires Mr. Cope to sign on to Zoom to provide that statement himself, I ask that he be available to do so, and I could ask him to sign in at the court's pleasure. Given everything that's happened, Your Honor, I tallied my time into this case. For the month of May, Your Honor, I billed my client 2.25 hours. For the month of June, Your Honor, I billed my client 3.25 hours. And for the month of July, Your Honor, I billed my client 12.25 hours, given all the back and forth between myself and Miss Davis, and myself and my client, and myself and Friends Indeed, in trying to get the amounts paid. That totals 17.25 hours total in this case. My client has been severely damaged by the goings-on in this matter. And for that reason, and for the reasons that are very much more articulated in my motion, or excuse me, my response to Mr. Henry's motion, I'm asking that the court award my client actual attorney's fees at whatever reasonable rate Your Honor deems the appropriate rate, and based on the 17.25 hours that have been put into this case since the very first hearing in May, when I questioned whether or not Miss Davis was being forthright with the court.
Is Miss Davis out of the unit?
She is.
Ms. Davis has told me that she's out of the unit. She's sleeping in her car in the driveway of the unit.
I was unaware that she was sleeping in the driveway of the unit, Your Honor. I would have to ask my client about that.
Your Honor, I will say, if this is about miscommunication, that's pretty much all my clients, and I definitely empathize with the delays that this has caused in this case. I think the main issue, though, seems to be the allegation of the dishonesty. And I see that in Exhibit A12, 5, F6, 5, and 4. But what my client's position has been on this is when she said that she was waiting, according to Friends Indeed, she was waiting to get that ledger so that she could give that to Friends Indeed. She couldn't get any money from Friends Indeed until she had a ledger that showed she had $3,000 or less owed on the balance. She had been calling them and communicating with them, and admittedly, she had been doing it not always.
But Mr. Henry, even after the point at which the 6,200 from the court is applied, she was supposed to pay some money. There wasn't going to be a $3,000 ledger because she didn't pay the money.
She does maintain that she did pay that money, and she doesn't state anywhere here that she didn't pay that money in the exhibits that were shown.
She did pay it, Your Honor. Sorry to interject, Mr. Henry. I just want to clarify. She did pay it, Your Honor. She paid it on Sunday, the 19th, with money orders that are attached as exhibits, Your Honor, and there was a subsequent $50 payment that following week, Your Honor. That is all spelled out in the motion. I didn't articulate that in what I verbalized to the court. I will clarify and confirm Mr. Henry's statement. Yes, she did ultimately pay, but it was after multiple dishonest statements. And even at that point, my client was still willing to move forward with the Friends Indeed payment, but for Ms. Davis, again, providing a dishonest statement regarding the availability of the check. But I'll defer to Mr. Henry.
Right, and I wanted to, if I finished it, at some point, she doesn't pay it, at some point she does pay it. But then there's this whole issue with Friends Indeed.
Yes, Your Honor, and I do agree that Friends Indeed, the process which takes place, she applied in June, and then once they didn't have the payment made in June, she got pushed back to the line. She got moved up quickly in July. But then obviously she would have to reapply in August again. That is an unfortunate process of Friends Indeed. They need that ledger and it needs to show $3,000 or less. She could not have had that ledger until at least after July 15th, because that's when that escrow payment was made. And I do agree that there was no payment from her that showed up on the ledger until July 20th. But she does maintain that she paid those on time. For whatever reason, they weren't showing up. She was told not to wait to pay the landlord, but she was told to wait until she had a balance on the ledger that showed under 3,000 before Friends Indeed could support her with that financial assistance. So that message that she said she was told to wait, that was them telling her to wait till she had that ledger to show them, because she was communicating with them without the correct documents. And I fully admit, Your Honor, she is not always the best at communicating. Friends Indeed, I think they're on here. They will tell you the same thing. But she has made that payment. There was the release of escrow. The only thing that's remaining is that Friends Indeed payment.
How many opportunities, Mr. Henry, is a landlord supposed to give?
I definitely agree, Your Honor, and it's very difficult.
Well, no, I mean, I'm asking that question because, I can tell you there was certainly a time where sometimes it was Miss Dornbush would be pushing this court, say within her rights, to just immediately go forth aggressively. So I think over time, everybody has realized that in this day and age, that opportunities need to be given to people. And sometimes, much to the dismay of the landlords, I'll give people opportunities to get things done. They'll tell me they're going to make a certain payment. They may need that next hearing to do the other payment. And I realize as I'm doing that, it's costing the landlord to have to deal with that and do that. But it's in part to sort of be equitable to both sides. All right, a landlord without tenants that doesn't help them, and a tenant without housing, that certainly isn't helpful for anybody either. When I got Ms. Dornbush's response, and I realized that Ms. Dornbush works with the funding agencies, and she tries to make sure all the I's are dotted, T's crossed, getting the person to bring the payment in, maybe sometimes cajoling her client to do something because the judge is going to do this anyway. However she does it, giving people an opportunity to get things done. When I got her response, because usually Ms. Dornbush, she's very thorough and writes thorough responses to the court. I was amazed at it because I don't know that I've received anything this long, but went through it. And I was, on behalf of her client and Ms. Dorn, I was astounded at the number of opportunities, given what was being said, that they gave Ms. Davis. I not because they're not good people and they wouldn't do that. I'm not saying it for that reason. I
wish I had gotten in this case sooner, because I don't think this is something that my client could resolve on her own. I think she does need someone to make sure she's getting the right documents to the right people in the right time, which is why we.
But you know what, Mr. Henry, I appreciate you saying that. But I have all kinds of tenants coming through here, and I realize they are at different levels of expertise of trying to get things done. And you give that opportunity, but you see the effort. Ms. Dornbush has been a victim of me giving somebody credit for the effort, but they didn't quite get it done. But I say, okay, we got to give them another shot. They were trying to do it. They just didn't do it. That's not what this is about. I think, quite honestly, and this is what frankly hurts those tenants that are trying but may not have all of the ability to get it done and where they need a break. A case like this one hurts those tenants because it's hard to say Miss Davis didn't know. Miss Davis understood enough to be able to reach out and try to grab the resources that she could. She had that going for her. But I'm going to tell you, I think in terms of the representations that she made to the landlord, I think she's out and out lying too. I get why, because I want to buy more time. Right? That's why I'm lying to you. But she's out and out lying. And that's problematic for a lot of reasons, not just because of her case, but it's problematic for other tenants' cases who may need a break, but don't get the break because this is where they are. I will also say this about, because I deal with these landlords all the time, about Arborwoods. Arborwoods will work with their tenants and to do it. They make, in my opinion, they make very rational decisions about who's going to get this and who I'm going to work with. But in general, they'll work with their tenants. For them to get to a point where they say, we're not doing anything, it takes a bit, in my experience with them. Right. But I understand why they got there at this point. Frankly, I don't know that I would have faulted them if they had gotten their 5 steps back. I mean, this is just, doesn't make any sense. What are you asking? It's your motion. What are you asking me to do? I mean, because when I read the motion, I'm familiar with this case to a certain extent, not the detail that Ms. Dornbush was, but that was one of the reasons I denied it. What are you asking now that she's out? What are you asking that the court do?
Well, Your Honor, this was filed before she was fully evicted from the property. So this obviously changes what we're asking for. In this case, we would ask that she be able to re-enter the property once she pays the August rent. That way, that would allow her to reapply for August for Friends Indeed to get that $3,000. I have spoken with Nakia Smith.
So hold it. Just so I'm clear, you want me to let her back into the property that she voluntarily surrendered with a balance? Oh, wait.
She disagrees that she voluntarily surrendered. She was told by the court officer that she had to vacate the property. She didn't think that was something. She said they changed the locks, stop them from changing the locks. And we had prepared her. When I filed on Friday, I told her, I don't know what the court's going to rule. You should be prepared to leave on Monday if they rule. So that's why she had the truck there ready for her to go.
Your Honor.
I don't really need a response to that. I'll let you respond. I'm not doing that. She's out. However that occurred, I don't think it's through anybody at Arbor One or Miss Dornbush or anybody else or the court officer tricking her into that.
I don't think it was a trick, Your Honor. I think she was scheduled to leave on Monday and there was no stop to the writ. So
I did not stay it. And I think for good reason I didn't stay it. But I did not stay the writ. She's out. So to the extent that your request is that she go back in,
I wasn't sure what would be going on at this hearing. I did ask Wednesday whether that would be something that would be an option, because that was the only real reason to go forward with this motion.
I don't think there's any real reason to go forth with this motion. My problem is this is a non-payment of rent possession case. She has not paid to keep herself in the unit. So I don't know why we're here either. And if you think I'm going to put in, and if it had been a circumstance where I had stayed the writ, but they executed it, or the court had done something along those lines, but she's out and she needs to be put back in her unit, fine. But I believe that she voluntarily gave up the unit. Whatever her mindset is, she voluntarily gave up the unit. And quite frankly, had this whole thing that Mr. Dornbush put forth to become before me before, it wouldn't have been anybody's voluntary anything about her not being in the unit, because I would have signed that writ, she would be out, and I would not have stayed it, given everything, or at least even part of what I've heard. So to the extent that's your request, I'm going to deny that request.
Understood.
Is there any other requests that you are making of the court today?
No, I don't know.
All right. What I'm going to do is let me take a brief break, because I'm going to tell you, Mr. Henry, I'm a little. I let attorneys operate. I realize also attorneys are operating based upon information that's provided by their clients. But I also think, with reference to that, information has to be filed in good faith.
Your Honor, I did, as Ms. Dornbush said, I did try to reach out to her before filing, and I was not able to talk with her because I had not had an appearance. When I did submit the appearance, she did file that motion, or that response to my motion. She's nodding her head no. I think she disagrees.
Yeah, I disagree with that assertion, Mr. Henry. You and I had a phone conversation. You told me you were filing the motion, and I told you I was happy to speak with you after filing the motion, or once I had your appearance about the details. You could have prepped your appearance Wednesday afternoon and sent it to me, and I would have spoken with you in detail about what had occurred. Further, if Ms. Davis, yourself, whomever, was treated this as the emergency you stated it was, and you're filing on Friday at 2:45 p.m., the motion would have been filed at 8:30 a.m. on Thursday morning to have the court's consideration, instead of an hour before the court closed. And I mean, from the business hour perspective, 2 hours from a business perspective before the court officer would be prepared to go out and execute an order of eviction. I mean, to say that you tried to reach out to me, but we didn't get a chance to talk, is not a truthful statement, Mr. Henry. I told you exactly how I intended to respond to your motion before you filed it. I made it very clear to you on the phone on Wednesday afternoon what to expect in a response.
Your Honor, she did tell me she was planning to file a response. She wouldn't give me the details of why. I did file on Friday. I was waiting for a sworn statement from the Friends Indeed worker, Nakia Smith. I didn't have that until Friday, so I couldn't submit it until Friday. The writ was good to issue on Monday, so I was calling the court to see what could be done about that. We emailed on Monday. I said she didn't agree to move out. I said she had the locks changed. You said that was incorrect. I asked, had the locks been changed? You said that was correct. On Wednesday, when we had the hearing scheduled, I again reached out to you. I asked the court what the hearing would be about, since she was already evicted. the court,
Well, hold it. No. And it, she wasn't evicted.
I stated to the court that she was no longer residing at the property. I was told by Ms. Dornbush this was incorrect. I asked her what the correct information was. She said, I will see you in front of Judge Simpson. So I didn't have a chance to withdraw that if that was incorrect information. I've been told multiple times by Ms. Dornbush what I say is untrue, but she doesn't correct what I say or tell me facts that are different.
I don't. I don't know that that's her job.
Well, Your Honor, I
The
can't.
job starts with you using your best efforts to verify that the information that you put before the court is true.
And I did so to the best of my abilities, Your Honor. I acted in good faith. I reached out to opposing counsel to see if they had alternative proof, what their positions were on the matter. I talked with my client. I don't know if there was other alternatives I could have done in that situation.
I'm happy to respond to that, Your Honor. And I can
I don't need
clarify.
it because I'm just gonna say this, Mr. Henry. Even up to this point, after hearing everything on the record, you referred to her as being evicted. She wasn't evicted. You try to make it sound, and I don't know if you're, well, maybe you are trying to make it sound this way, as though somebody cajoled her or did whatever for her to turn in the keys or change the lock.
I apologize if that's what I gave. My understanding was she had a judgment. The writ was to be issued on Monday. The writ was delivered by the court officer. He told her she had to leave by the end of the day, and she did leave by the end of the day.
Right, but
she was not forced out. There was no police involved. She was told to leave, and she did.
Your Honor, the writ wasn't delivered on Monday.
What?
I would have to verify exactly with Mr. Cope when he originally posted the writ, but I suspect that it was posted on or around July 18th when Ms. Davis emailed me wanting to understand how the writ had been issued by the court. The writ was issued.
I had got two different writs, Ms. Dornbush. It was one on the weekend when I responded to you. And then after the fact, after with Friends Indeed, when you spoke to them, because you said I had to requalify, but they were willing to give the payment. And I'm like, the payment puts me at 0 from Friends Indeed. Y'all put another thing on my door. I took pictures of it. The first time, y'all put it on there twice. And all y'all did was copy the second one and put the date for Monday. And he was there on Monday. But the first weekend that you said it and told me that I had to be out on Saturday, the writ was put there on Saturday, and then it went for another week. I kept calling Officer Moore, and he said he did not have a date. And then another one was put on there, like on Saturday again, saying Monday the 3rd, after you sent the email and all of that, but 2 were posted on the door with 2 different dates.
Your Honor, that
I never
tracks.
gave him permission.
Your Honor, that tracks. That the originally issued order of eviction by this court, which I believe happened around the 15th or 16th, the 15th or 16th, would have been posted by Ed Cope or one of his colleagues on or shortly before July 18th. Yes, he did reserve the order of eviction after Arbor Woods decided that it was not going to continue this process with Miss Davis. And that was short. If she says it was on Saturday, July, or would have been August 1st, then perhaps it was. Mr. Cope could sign in and verify that for Your Honor. But I had already made it clear
it matters.
that it was.
I did not sign 2 writs.
Yep.
What he was doing was he was re-giving notice of the eviction, which is absolutely proper and actually is what should be done where there's been a large time that has passed and where there have been attempts at an agreement to rectify the rent. So that part does.
There on the 15th.
And to clarify, Your Honor, I in no way told Miss Davis that she needed to requalify the next month. I simply said she wasn't getting assistance this month. It's not my place to tell her what she will qualify for at a later date. That's between her and Friends Indeed. I said she was not eligible to receive assistance this month and that they were not waiting for additional payment. I did not tell Miss Davis in any way, shape, or form what she needed to do to qualify for assistance in August.
All right. Okay, unless there's anything else, I'm going to take a brief break. I think, and I'm just going to let you know that, and I want to take a look at something that when I look at this case, I indeed think that sanctions may be appropriate. And so I want to go deal with that, and then I can come back and give you my ruling on that request by plaintiff's counsel. Court is standing recess. Okay, back on the record in the matter of Arbor Woods versus David. In this matter, the court has taken some time to consider appropriate sanctions in this case. It's also that was divided by 2, correct? No, that's for the 17.5 hours. And give me. She missed a number. Well,
Okay.
that was times 12.25.
Yes, sir.
Give me a number again.
$3,638.25.
All right. The court, in looking at this case and feeling that sanctions are appropriate, and I want to make this very clear. The actions that occurred in this case, so that the record is clear as to Mr. Henry's conduct, that, and in filing the motion and doing whatever, attorneys are placed in a very difficult position when that happens, because they have, when you say these motions have to be filed timely, there is not really a necessary time frame. It's, you got to get the motion to the court before the writ gets executed, which sometimes in and of itself, you don't know when that is. And so the ability of an attorney to check, verify, recheck, the court is very well aware, is limited. And so the attorney is placed at times in a position of going on what their client says, in a lot of ways can be sometimes to the attorney's detriment. So I want it clear on the record that the imposition of sanctions in this case is not the court does not believe that it's legal services or Mr. Henry that should be receiving sanctions in this case. And the sanctions being the actual attorney fees to a point in this case. But I am going to award sanctions in terms of actual attorney fees as against, and solely as against Ms. Davis for her misrepresentations, not only the plaintiff's counsel, but what I believe, given what was passed along, are misrepresentations to her counsel, then placing counsel in a position of putting forth what may be false and inaccurate information to the court. So my calculation, some of this is in essence really the cost of doing business in a particular case. There were a total of 17.25 hours. I am going to award sanctions on the 12.25 hours, which is that latter portion, which quite frankly would have been unnecessary absent the misrepresentations of Miss Davis. So that is going to total, and then that's going to be based upon what is the average attorney rate in the state of Michigan of $297 an hour. So I'm awarding sanctions in the amount of $3,638 to the plaintiff as against solely Miss Davis, specifically not against legal services or Mr. Henry. Counsel for the plaintiff will prepare that order. Also include in that order, just so that we can make sure the premises is secure, that if plaintiff can execute the writ, change the locks on all of the doors to make sure those premises cannot be entered. That can be included in the order so that you don't have to come back to the court should you find something for further relief.
Thank you, Your Honor. And I did verify with the court officer the order of eviction in, so I'll just indicate that upon this order that plaintiff can make those changes, correct?
Yes, plaintiff
Okay.
can secure all entries to the premises, including all the doors to the premises.
Very good, Your Honor. I will get that prepared and submitted to the court as soon as I can.
All right, and I do also, I think, Mr. Henry, there was indication during the hearing, just so that it's clear on the record. I think when you filed it, there was not an immediate response from the court, which is not my normal practice. I happened to be trying to take a little vacation. So I did not get back to everybody as fast as I could, but once I came back, it was brought to my attention. We got to you as soon as we could. All right.
A well-deserved
Thank you.
vacation, Your Honor. Very much
Yes.
so.
Thank you. All right. Thank you, folks. Everybody
Thank
have a
you.
wonderful, blessed weekend, please.
You as well, Your Honor. And before we sign off, Your Honor, I think Maddie has been with our firm long enough for quite some time, and I thought you had met her previously, but if not, I wanted to introduce you to her. Maddie, you want to turn your camera on? So this week marks Maddie's first week back with us after sitting for the bar exam last week. So we are all very anxiously awaiting her bar results. And you've seen her before. I just don't know that we did a formal
I don't know. Have I seen you before? Because I see it labeled that you're there, but like the camera's not on.
Yeah, typically. I feel like I've maybe popped in once or twice with Rachel where I've actually turned my camera on, but I typically have it off.
Where'd you go to law school?
University of Toledo.
Good. Well, that's okay. It's in the disputed territories, but we'll accept that.
Yeah.
All right. And how'd the bar exam go?
We finished it. I don't know how it went, but it's done.
I got done. And they let me leave. I'm good.
I'll take it for now.
I'm sure you will do just fine. Are you a Michigan native or?
Yes.
What part?
I'm from Traverse City.
Oh, yeah, that's way up there. Okay.
Way up there.
So that part of Michigan. Okay. And where'd you go to undergrad?
Michigan State.
Okay. We could get along, but not. I'm a Terrapin. I don't like Spartans. But
that's fair.
I'll figure out a way to deal with you.
We'll figure it out.
It's a pleasure meting you officially this time. All right. And good luck. My prayers will be with you on those results. I know the wait is crazy.
Yeah.
It is indeed. For all of us, for Maddie, but also for us. You know, we are very eager. Thank you, Your Honor. Have a great weekend.
Well, you guys have a great weekend. All right. Take care.
And I would say, I hope all of you have a great weekend. Those of you who don't plan on showing up for Saturday brunch or Saturday evening, have a great weekend. But if you're coming by tomorrow for brunch, looking forward to seeing you then. It's just a few hours away. We got a big case with Judge Brantley Clark Jr. down in Panama City. The lady was transporting a whole lot of naughty stuff. And she said she was being forced to do it by cartel. It's a whole story. She's going to tell us all about it on the stand. Real interesting. Then tomorrow night, we're going to watch a case with Judge Stevens. Real interesting case. It's a bench trial hearing, revocation hearing thing. Amazing. Hey, speaking of amazing, look at all these amazing names scrolling across the screen right now. Thank you all of my great friends. I want to say a special thank you to X25, Miss Natasha Kitty, Darth Steven the Deplorable, Darth Steven the Deplorable. Oh, did I mention Darth Steven the Deplorable? And most especially, Charlene Tuck. Thank you so very much, Charlene, for that very generous super chat. I thank you. You tell me I'm your favorite channel all the time, and I really don't deserve it. I don't deserve it. Let me do the chat. I don't know. That's not the right thing. That's not the right thing either. That's the right thing. Okay. I knew we'd find it eventually. Look at that chat. Look at it going on over there. We are going to redirect Hutch. He's got a real interesting sovereign citizenry thing happening, like right now. So go grab some warm tea, some hot cocoa, some hot coffee, whatever you need for your late night court needs, and get ready for more court. You got what we got here, and then you got more. I got. I'm just an old wolf who's tired. It needs to get ready for a really long day of court viewing tomorrow. What product do I use to broadcast? When you say product, I mean, I use the good old-fashioned open broadcasting software. It's called OBS. Very free, very open source, very available to everyone. You just point it at your destination. Like me, I pointed at YouTube, and then it transmits stuff out to YouTube, hopefully at a dependable rate without any interruption. That's how it works. That's how it works. Any other questions? Night, Straw Carpenter. Night, Marty. Night, Mama. Chat has been wonderful tonight. Make sure you tune in tomorrow, 11 a.m. Central Time, 12 p.m. Eastern Time, for more court than you can shake a stick at. Judge Brantley is going to be a fun one. It's about 2 hours and 45 minutes long, so just buckle up, have your brunch goodies ready, and meet me back here for the same wolf time, same wolf channel as we do every single weekend. And for now, I'm your lone wolf Uso. I am out. See you guys. And remember, only you can take a bite out of crime. Bye! Y'all.